Hello, my name is Breck Wainwright. This is going to be the oral portion of the first exam for the Wildlife Policy course at Clemson University for the fall 2023 semester. The main topic we're going to be talking about is the Held versus Montana court case. The plaintiff's main argument in this case is that the state of Montana violated their constitutional right to a clean and healthful environment that is supposed to be promised under the Montana Environmental Protection Act. Montana's support of the fossil fuel industry had worsened the effects of climate change on their lives, both physically and mentally. Additionally, plaintiffs challenged a provision in MEPA that prevented the state from considering greenhouse gas emissions as a factor when issuing permits for energy-related projects. So, for example, a company wants to open up a new crude oil field in the middle of the state. Well, they're able to get that oil field to get off the ground and build and get a permit to do that without even having to consider the greenhouse gas emissions that that oil field would release. Moving on to the state's argument, Montana argues that only regulatory acts can be used as a basis for permit rejection, and Montana state law doesn't allow permits to be denied based on climate impacts. So a good example of this would be the Montana Clean Water Act can be used as a justification to issue or not issue a permit, but MEPA itself and other state laws can't be used to issue or not issue a permit for green for greenhouse gas projects or fossil fuel projects. The state of Montana also claims that they're following current state regulations and the state constitution. They argue that climate change in Montana is a drop in the bucket compared to other global emissions around the world. And lastly, Montana's contributions should be addressed in a state legislature and shouldn't be addressed in the state courts. So why was this court case so important? Well, the case became the first climate-related constitutional lawsuit to go to trial in United States history. The decision allows Montana's policymakers to consider greenhouse gas emissions and climate impacts in future energy projects. Uh, Although it has to be noted that the state legislature and policymakers are not obligated to consider greenhouse gas emissions and climate impacts yet. The case also provides a blueprint for future climate suits, and this will be especially useful in states that already have environmental protection provisions within their state constitutions, similar to Montana. This case was also the first to ever prove a link between uh, greenhouse gas emissions and the negative impacts those gases have on young people's lives. And last but certainly not least, um, it'll help us rethink targeted challenges to specific laws. So the claim in this court case was pretty narrow, and the plaintiffs weren't asking for a lot of recompensation, but it made it more likely that the court would accept their claim because it was so narrow and because there were no damages they were asking for in return. There's actually only 6 other states in the US that have environmental protection provisions within their state constitutions. Those states are Alaska, Illinois, Rhode Island, Hawaii, Pennsylvania, and Massachusetts. It was pretty shocking to me personally that Montana is the only state in the Western US that has one of these environmental protection provisions in its constitution. So a court case I was able to find that's nearly identical to Held versus Montana is Natalie versus Utah. And tell me if this sounds familiar. Youth plaintiffs allege that the state of Utah and other defendants violated their substantive due process rights to life and liberty under the Utah Constitution by maximizing, promoting, and systematically authorizing the development of fossil fuels. Utah's fossil fuel development policy and the defendant's implementation of the policy contributed to dangerous air quality and climate change that disproportionately affected young people. So, similar to Held versus Montana, the state of Utah let these fossil fuel corporations do as they will with the land, and the changes they have made to the climate and the environment through the release of greenhouse gas emissions has disproportionately affected the young people of Utah. And similar to that case as well, the defendants weren't looking for damages or recompensation. They were looking for declaratory relief, which means their lawsuit was pretty narrow, but they were mostly looking for the courts to acknowledge that the state of Utah violated their rights under the state constitution. The case was originally dismissed last year, but in January of 2023, the plaintiffs filed an appeal. Here's a few thoughts I was able to find from law experts on the results of Held versus Montana. Michael Gerard, the founder of the Savin Center for Climate Change Law at Columbia Law School, says this case will now make it harder to attack basic climate science in a court of law. I made sure to write the in a place where you theoretically can't lie with air quotes because I believe people will still lie in court if it serves their purposes. Michelle Bryant, a law professor at the University of Montana, believes the case and its decision will be read by judges all over the country and be used as a reference and an influence when deciding similar climate cases in the future. Additionally, she believes that Montana energy agencies will now have to consider greenhouse gas emissions for future energy projects. And finally, Roger Sullivan, an attorney with the McGarvey law firm in Kalispell, Montana, says the case establishes enforceable principles of intergenerational justice. In other words, the state of Montana is obligated to pass on a stable climate to future generations, which seems to be one of the main intentions of MEPA to begin with.